Welcome to the Laughing Litigator.
Hey everyone, welcome back to an all-new episode of the Laughing Litigator with attorney Ray Hsu. Ray has been teaching California employment law long enough to know that at-will employment sounds simple. You can fire anyone for any reason or no reason until California adds exceptions, warnings, and penalties that make every termination feel like a legal exam. Today, Ray's going to be breaking down what at-will really means in 2025 and beyond, what employers think they have complete freedom, but the law has a very different plan in mind. He'll talk about contracts, discrimination, retaliation, harassment, severance agreements, arbitration, and all the protections California layers on top of a rule that was supposed to be straightforward.
Okay, let's talk about the at-will employment definition under California laws. So it's important to know California employment default relationship is at-will. So even if you didn't sign anything, you didn't say anything, and you started to work for somebody or some company, the default relationship is at-will. And what is at-will employment relationship? Basically, under the at-will employment relationship, any employer or company can fire you for any reason or no reason, except they couldn't violate certain laws. And as an employee under the at-will employment relationship, you could leave a job with any reason or no reason. And this is actually important for certain, especially for certain immigrant workers who actually came from a foreign country, because in many Asian countries, although a lot of the situation is like at will, but some Asian countries, they actually would impose the law saying something like, if you didn't do the transition work for your employer, even though you already resigned or terminated, the employer can deduct the last month of wages because you didn't cooperate with providing the transition. But under at-will employment, employer cannot force you to stay to provide any transitional work to the next employee who's going to take over. If you leave, you leave. So under the at-will employment principles, nobody will have to work like a slave after being terminated or resigned from the work. So with that being said, even though the employer can terminate you for any reason or no reason, but we all know there are many other California laws that prohibits illegal firing, discrimination, and harassment. So let's take a look at the exception to the at-will employment. So the first one is, even though when the employment in California was is at will, but still it cannot violate any contract. For example, a written contract said your employment is guaranteed until the end of this year, but you were terminated right now. So this could be a violation of a written contract. Second, the termination cannot be based on discrimination, and the discrimination is based on protected category. So discrimination is never about any discrimination. It has to be protected category under the California Government Code 12940 subsection A. It has to be based on race, gender, sex, pregnancy, age, disability, or skin color, ancestry, marital status, sexual orientation, or military or veteran status. And of course, it cannot be based on sexual harassment. And the third is no illegal retaliation. So the illegal retaliation definition under the Labor Code, Section 1102.5, is after you reported certain illegal act of the employer, either internally or to a government agency based on federal, state, or any local rules, and the employer cannot retaliate against you based on that. And then let's talk about specific exception in detail. And today in this legal podcast, I want to briefly talk about the second exception under the Government Code 12940 subsection A. So this is the California Anti-Discrimination Statute, California Government Code 12940 subsection A. And the California Fair and Employment Housing Act, with regard to employment discrimination, it actually it was enacted and became law actually before the Title VII of the Civil Rights Act of 1964. If you are interested in that part of the legal history, you can try to Google it. And I will also briefly talk about the illegal retaliation. What is illegal retaliation under Labor Code Section 1102.5? With regard to the second exception, I'm going to cover sexual harassment in the 2025 context. So basically, the prohibition against sexual harassment includes protection from a broad range of conduct, ranging from expressly or impliedly conditioning employment benefits on submission to or tolerance of unwanted, unwelcome sexual advances, to the creation of a work environment that is hostile or abusive on the basis of sex. So this confusing sentence basically can be translated into two kinds of sexual harassment under the California law. So basically, there are two types of sexual harassment under the Fair Employment and Housing Act. The first is quid pro quo sexual harassment. Basically, the employer is using work benefits conditioning on sexual flavors or to avoid negative job consequences. Or the employer supervisor were suggesting submission to body contact in exchange for work benefits or to avoid negative job consequences like a bad review, loss of bonus, or even termination of employment. And consent is not a defense, but it sometimes will also depend on circumstances. And the other type of the sexual harassment, which a lot of people heard about it and also misunderstood the definition a lot, is the hostile work environment. Basically, under this definition of hostile work environment, the element of this hostile work requirement, it has to show either severe or pervasive harassment. And it's based on sex or protected characters. And it's unwelcome, and it also have to be objectively and subjectively harassing. That means a reasonable person or a reasonable woman has to find it objectively harassing or hostile. So it's important to understand what sexual harassment is not. So workplace harassment, even harassment between men and women, is not automatically discrimination based on sex or the hostile work environment harassment, merely because the words used have sexual content or connotations. So basically, the courts and the legal doctrine in California repeatedly want to emphasize, even though people may heard it from the TV and the news, that somebody sues some government agency or some big company and make hundreds of thousands of dollars in settlements and millions of dollars in jury verdict. But after all, Fair Employment and Housing Act is not a civility code and is not designed to rid the workplace of vulgarity. While the FEHA prohibits harassing conduct that creates a work environment that is hostile or abusive on the basis of sex, it does not outlaw sexually coarse and vulgar languages or conduct that merely offends. And in some old case law, what we have seen in 1998, 1993, and also 1990 in slide 13. So in some old cases, what we have seen 1998, 1993, and 1990, there are some interesting old cases that just to share with the podcast audience. It doesn't mean if you do the same, nothing will happen to you. We are in 2025. Some standards are different. But let's look at in 1998, 1993, and 1990, some of the cases that the courts just wouldn't recognize the sexual harassment. For example, in the 1990 case, Queen versus Green Tree Credit Corp, harasser statement that plaintiff had been voted the sleekest ass in the office and single deliberate act of touching plaintiff's breast with papers he was holding in his hands held insufficient to be sexual harassment. That's the 1998 case. A 1993 case, insufficient when the supervisor told plaintiff how beautiful she was, repeatedly asked her out, tried to kiss her on three occasions, put I love you sign on her work area, and touched her shoulder at least 6 times. In 1993, this case, it was insufficient for the plaintiff to show sexual harassment. And in the 1990 case, Chamberlain versus 101 Realty Inc., 5 sexually motivated advances on plaintiff over a 4 or 5 week period held insufficient for hostile work environment. So why am I showing these 3 types of cases? While there are lots of sexual harassment being filed in superior court and federal court, courts actually scrutinize each plaintiff's case to make sure they really have a real sexual harassment case and not in the situation that a plaintiff just want to take advantage of a situation and make big money off from the employer. And of course, we are in 2025, 2026. Even though I shared the 3 cases, but if you do the same thing in 2025, 2026, serious consequence will take place. So please do not try to imitate what people did in the old time. So as an employer, you may discipline or terminate any employee who sexually harass any other coworkers, supervisors, or even clients. But sometimes you will face, as an employer, will face a situation that the employee try to make a false sexual harassment claim just to blackmail the supervisor or try to protect his or her job. For example, the person knows you are going to fire her. So then he suddenly tell you, oh, I was sexually harassed in the past few days because of A, B, C, D, E. When that happens, you cannot immediately fire this person. Otherwise, there's going to be a retaliation case issue. You have to investigate and make sure the person was reporting a right claim or a false claim. And if the person was reporting a false claim just to blackmail or just to protect him or her from being terminated, then after proper investigation, documents, and document all the statements, then you will still be able to fire this person. Let's come to the 2019 amendment. So remember, I previously talked about the 3 cases that in federal court was determined insufficient to show sexual harassment. So basically, labor employment law, especially discrimination, sexual harassment, and retaliation became fact-intensive litigation, which means each case, even though similar, but because certain people, certain things happen at a different place at a different time, and sometimes at the right time, sometimes at the wrong time, and then each case came out with different results. So there's a 2019 amendment saying that they are modifying the severe or pervasive legal standard for sexual harassment so that a single incident of harassing conduct is not sufficient to create a triable issue of fact regarding the existence of a hostile work environment claim. So that means after the 2019 amendment, the chance of not being able to settle the case and to go to a trial or jury trial will significantly increase with a single incident of sexual harassment, which is very different from the 3 old cases I just mentioned before. And also in AB 3109, after January 1st, 2019, if you sign a settlement agreement or severance agreement with an employee who reported sexual harassment, in this settlement agreement or severance agreement, under the so-called Silence No More Act in California, you actually cannot have a confidentiality provision for the sexual harassment part of the claim. And the employee will always be able to report or talk about it in the future. Again, you can probably imagine the Silence No More Act is also the part of the result of the Me Too movement in California. So briefly talk about sexual harassment. What are the potential liabilities? If the person or the victim was physically assaulted or sexually assaulted, there could be criminal liabilities. And most often, if the case is a civil case, there's going to be a front pay, back pay issue, past emotional distress and future emotional distress issue, medical costs, punitive damages, attorney fees and costs, and court costs that could potentially become a very expensive case for any employer. That's why FIHA requires every employer, the supervisor has to go through 2 hours of sexual employment training and 1 hour of sexual employment training for non-supervisory employees. The measure to require sexual harassment training is actually a way to help the employer to prevent litigation. In 2024, 2025, in Los Angeles Superior Court, based on certain information from the Superior Court, each judge is handling between 6,000 to 1,000 cases in every individual calendar department judge. And at least a third of the cases are employment law cases. And also talk about the tax treatment very briefly. If you or your company settle a sexual harassment claim, the settlement is not tax deductible in any way as a business or legal expense. Let's briefly talk about employer protection. Well, employer a lot of times use severance agreement to buy out any leaving employees' litigation rights or to sue for most of the claims, but cannot waive workers' compensation claim and cannot waive unemployment insurance benefit claims and cannot condition on receiving the last paycheck amount as the only severance pay and cannot have a confidentiality agreement for any sexual harassment claim. That should be every employer's common sense by now. And also, I want to talk about the arbitration agreement. There's a lot of news about arbitration agreements. A lot of the case law under California Court of Appeal, California Supreme Court, and even United States Supreme Court regarding the arbitration agreement. California courts hate it. California courts thinks everybody should be entitled their jury rights, even though each civil judge has close to 1,000 cases now. But to some extent, California courts has high suspicion regarding arbitration proceedings. Arbitration proceedings in employment law context has to be paid by employer. With that being said, so the legislature push the arbitration proceeding to become more expensive to the employer, but at the same time suspect that because it's paid by the employer, therefore it may be biased against the employees. So a lot of legal maneuvering, a lot of the case law or statute are trying to cure or balance the effect, and eventually becoming very, very complicated. So for every arbitration issue, especially employment law context, every employer needs to consult a lawyer. But I also want to share my experience regarding the problem in arbitration. So to basically educate my podcast audience, whether or not you really want an arbitration agreement, or sometimes when the employee sue you, you don't necessarily have to send every case to arbitration. And here are the reasons. First, arbitration cost is often 10 to 100 times more expensive than you would pay in any court of law for court costs. And in arbitration, you must pay arbitration bills on time, or the case in arbitration got sent back to court, plus penalties. So this is another California law trying to balance the situation that some employers always try to send the case to arbitration, but didn't pay the arbitration bills on time. And third, the arbitration is not designed for every case or every type of employers, because of the cost issue alone is something that's very serious for every employer to consider. And also, an arbitrator selection is also very important. When you and your lawyer select an arbitrator, you must read through each arbitrator's background. For example, I myself is also a California attorney fee dispute arbitrator. We went through a lot of trainings. We went through a lot of learnings. But after all, we are not real judges. So from time to time, most of our arbitrators are excellent arbitrators, excellent lawyers who really understand the law. But we actually at one time pick an arbitrator who's so in favor of employee and will send the case to class arbitration only until the class arbitration panel lawyers reverse the individual arbitrator's decision. And then we had to do everything again and eventually resolve the case. So picking an arbitrator, you really have to understand the background. And I think that would be all today for today's podcast.
That's it for today's episode. Thank you, everyone out there, for listening to another installment of The Laughing Litigator with Ray Hsu. If you want to connect with Ray and his team, do me a favor, visit rayshulaw.com today. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.